UP Law Center suggested answer to the 2022 bar exam question in civil law. Question. Before they married in 2000, Nonoy and Daday signed a marriage settlement wherein they agreed that their property relations as husband and wife would be governed by the conjugal partnership of gains. While the marriage was subsisting, they acquired a parcel of land using conjugal funds. The Register of Deeds issued a transfer certificate of title over the said land in the name of Nonoy, married to Daday. Nonoy sold the parcel of land to Barbie without Dadai's consent. Dadai was not aware of the sale and did not sign the contract of sale. A year after Nonoy and Barbie signed the contract of sale, Dadai died. When the children of Nonoy and Dadai learned about the sale to Barbie, they questioned its validity since Dadai had not consented to the sale. Nonoy's position is that Dadai's consent was not required because the property was registered in his name. Question. Is the sale to Barbie valid? Explain briefly. Suggested answer. Yes, the sale to Barbie is valid with respect to the undivided one-half portion owned by Nonoy, but invalid with respect to the undivided one-half portion belonging to Daday. The property sold by Nonoy to Barbie is presumed to be a conjugal property of the spouses Nonoy and Daday because the same was acquired during their marriage. Under the law, a property acquired during the marriage in the regime of conjugal partnership of gains is presumed to be conjugal even if the same is registered in the name of one of the spouses. Article 116 of the Family Code. In conjugal partnership, the sale of a conjugal property by one of the spouses without the consent of the other spouse would have been invalid in its entirety. In this case, however, the sale can be already upheld as valid with respect to the undivided one-half pro indiviso share of the transacting spouse because the conjugal partnership was already terminated by the death of Daday, and by reason of such termination, Nonoy had already acquired an undivided one-half pro indiviso share in the subject property which he could validly dispose of without the consent of Daday. This disposition is in line with the well established principle that the binding force of a contract must be recognized as far as it is legally possible to do so. Quando res non valet, ut ago valeat quantum valere potest. And there you have it. We're done. Thank you for watching.